Hello. Today we're going to talk about mental health care directives. My name is Gregory Singleton. I'm an estate planning and probate attorney located in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just a reminder, if you like today's video, please feel free to smash that like and subscribe button. It really helps support the channel. Also, a couple caveats before we get going. First of all, this is not legal advice. These videos are for educational purposes only. And secondly, we're going to be talking about primarily Minnesota law in this video. So if you live in another jurisdiction, the law, especially in this area, may be dramatically different. So make sure to talk to an estate planning professional before you proceed with your estate plan. So what am I talking about when I say mental health care directives? Well, essentially, a mental health care directive is a health care directive that focuses on the specific needs of mental health, such as someone going through a mental health care incident or having and developing dementia or Alzheimer's. In preparation for doing this video and for my own practice, I did a 50-state survey to find out what other states were doing mental health care directives, and I found some good results and some bad results. On the one hand, you have states like Washington State, which has a very comprehensive and very well-written mental health care directive. On the other hand, you have states like Minnesota that don't have a mental health care directive at all. So in one sense, Minnesota likes to believe it does address mental health care directive because it has a provision that deals with electroconvulsive and neuroleptic medications. There's a lot more to mental health care than electroconvulsive therapy and neuroleptic medications. So in my opinion, Minnesota's behind the eight ball on this one. So the question, if Minnesota doesn't have a mental health care directive, is can you do a mental health care directive in Minnesota? Well, if you look at the statutes, my answer is yes, you absolutely can. Minnesota Statute 145C.05 Subdivision 2, it says what provisions may be included in a healthcare directive. For example, a healthcare directive may include provisions consistent with this chapter, including but not limited to, and then it gives an express list of things that can be included. But this opens a door. It says that may be included but is not limited to. In my opinion, that means we can talk about mental health all we want. The big difference that someone might see with a healthcare directive versus a mental health care directive, however, is the effective date. Is someone incapacitated? Remember, we are not just dealing with people that are incapacitated because they have dementia or Alzheimer's. We're dealing with people that are going through a mental health care incident, a crisis incident. The question is, are they capable of making mental health care decisions for themselves? Some people would say yes, some people would say no. As a lot of directives are written, you have to have a doctor or two doctors sign off and say that someone is incapable of making mental health care decisions for themselves before the health care directive kicks in. And what we're trying to do a lot of times with a health care directive is deal with things before that point. So, can you have a health care directive or mental health care directive be effective before someone is determined they are incapacitated? The answer is yes. If you look at Minnesota Statute 145C.05 Subdivision 2C, it says a healthcare directive may authorize a healthcare agent to make decisions for a principal even though the principal retains decision-making capability or capacity. So yes, if someone is in a mental health care crisis, they have not been determined to be incapacitated, you still can have an effective mental health care directive. So with that decided that we can have a mental health care directive, what goes in a mental health care directive? Well, there's a lot of things, and I picked 6 or 7 items that I think should be included in a mental health care directive. There's certainly a lot more that could be, but let's just go through the list here. First of all is your mental health care provider, often different than your primary care provider or the person you want making decisions if you have cancer or if you are in a coma. If you've been working with psychiatrists or a social worker or some other mental health care professional, you want to identify them. You want to identify who should be contacted if you're in a mental health care crisis. You can also identify who you definitely do not want to work with for mental health care. If you've had a bad experience with a doctor, you can make sure that they are not the ones treating you. Medications and treatment. You can say what treatments, medications are prohibited, what don't work for you. You can say they're prohibited as long as certain side effects are not addressed. But if those side effects are addressed, then you can go ahead and use that medication. You can always say that these medications help me out the most. It's a great place for that information. Another thing that Minnesota actually hits on is intrusive mental health treatment, electroconvulsive therapy and neuroleptic medications. You have to have certain magical language in a healthcare directive to allow or prohibit those treatments. Otherwise, you just may end up in court to have a judge decide whether it's allowed or not. Mental health interventions. This is if you start having a crisis, what can be done to calm you down and to maybe avoid going into a treatment center. You could list things that help you, such as calling someone, staying overnight with someone, going to a crisis triage center, having certain medications. Another thing you can do in a mental health care directive is you can consent to a number of days of treatment. You could say, look, if I'm in a crisis situation, I consent to 7 or 14 days in a mental health institution. In Minnesota, it's not necessarily enforceable, but it can certainly inform people what your desires are, and they will try to follow it. If you're in a situation for pre-emergency and what efforts need to be made before you get to such as seclusion or restraint. This is similar to the mental health interventions, but it can include things like if I'm in such a crisis mode and you're looking at giving me medications or restraining me or secluding me, talk me down first. That usually helps. Do a show of authority. Maybe do more medications. Give me a timeout. Give me privacy. Decrease stimulation. Whatever works for you, this is here to keep you out of seclusion and restraint. And the final thing I like to throw in there are people. People who should be notified if you're in a mental health crisis. Oftentimes spouse or brother or sister or a good friend are the ones that can actually come in and help calm you down. Also, you want to include people that you prohibit if you get institutionalized, say for a couple days in a mental health care institution. In my practice, I've been surprised at how many people do not want their mothers or their parents to see them if they're in a mental health care institution. These are oftentimes the first people that would be called if there was a crisis. But some people specifically do not want their parents called if they're in a mental health care crisis. So why do I bring this all up? And I think the reason that this matters so much to me is it matters so much to America. I get mixed reactions from clients when I say, here's a mental health care directive, are you interested in it? Some people say, I don't care, I'm not going to get dementia, at least not for another 50 years, and I don't have any mental health issues. Other people are very, very grateful to have this information. In the United States, 21% of adults experienced mental health illnesses in 2020. That's 52.9 million people, or about a little over 1 in 5 adults. For serious mental health illnesses and crises, 5.6% of US adults experienced serious mental illness in 2020. That's 14.2 million people and represents 1 in 20. For dementia, 1 in 3 seniors will die with Alzheimer's or another dementia. It kills more than breast cancer and prostate cancer combined. In 2009 to 2019, deaths from Alzheimer's increased by 145%. Worldwide, there are 10 million new cases per year. That's 1 case every 3.2 seconds. It's a shame that mental health is overlooked when we're looking at healthcare directives, when it is such a major part of our healthcare. If you are interested in this, find an attorney that will do a mental health care directive. It takes time to put one together that makes sense and is useful, but it's certainly doable with all the examples we have out there from the other states. So that's my take on mental health care directives. I hope you liked today's video. If you did like today's video, please feel free to smash that like and subscribe button. It really helps support the channel. I'm trying to get to 100 subscribers, so if you want to be one of them, it would be greatly appreciated. We do a new video every other Wednesday. We've got some fun videos coming up. If you have any questions or comments, leave them in the comments, leave them in the comments below, or just send me an email. Happy to get back to you. Otherwise, until next time, this is Gregory Singleton with Signature Law.